Hello, good evening and welcome to this edition of the program. Last Tuesday, I should say, we discussed the petition before the Supreme Court. As you know, the flag bearer of the new Patriotic Party for the 2012 election, Nana Akufo Addo, his running mate, Dr. Mahamadu Bawumia, and the chairman of the new Patriotic Party, Jake Obetsebi Lamptey, soon after the declaration of President Mahama as the winner and elected president of Ghana following the elections of December 7th, challenged the declaration and the victory of President Mahama in court. There was a big event last Tuesday where Ghanaians were told that since the petition was filed, the court has now agreed on the issues to be settled. And when these two issues are settled, we will know which way the case has gone. Now, on Tuesday, we spoke to the lawyers for President Mahama and the NDC party, and they explained to us from their perspective what the whole legal process meant up until this stage, what it entailed, what are the nuances, and what commentary they wanted to run on the things that have happened. Today, to be fair, and also in keeping with our practice of hearing both sides, or three sides, or four sides, or however many sides there are to a matter, we have invited, and they have graciously accepted our invitation, the legal team of the petitioners, to join us in the studio to explain from their perspective what it means. So I'm happy to introduce former Deputy Attorney General, I should say, Madam Nana Akufo, to the studio. Good evening, Madam.
Good evening.
Do you miss being Deputy Attorney General?
No.
You don't?
No.
You like, as you're doing now as a private legal practitioner, as it were?
Well, I don't miss being Deputy Attorney General because I must confess it was quite stressful. Mm-hmm. You were always in the limelight, sometimes for the wrong reasons. But I have learned to take my life by the day. And for me, each turn is a learning curve. So yes, I'm learning as I'm doing what I'm doing now. Mm. I have had a passion for advocacy and work in the court. But like most professions, as you grow old, you want to do something different. So
all the people involved in this case, and indeed the legal society, has said that this is a landmark sort of case. It's going to be a very big, it's going to represent a very big part of our legal and constitutional history. And on Tuesday, when I interviewed Dawudu, he expressed the same sentiments, and he felt excited to be part of the process. You've been a seasoned practitioner, and you have been Deputy Attorney General. Is it true that this is going to be a landmark case? It's going to occupy a very important part of our legal and constitutional history?
Indeed, there is no denying the fact that it's a landmark case in all respects, be it in terms of our Constitution, because it's the first time that it's been invoked to challenge the validity of the election of a president. And also in terms of the fact that it's never happened that a sitting president election is being questioned. So yes, but I think also that in terms of the law, it opens new areas of the law because it's a course that has never been charted. And it will bring into perspective what we can take from other jurisdictions. Because in terms of the case law, we haven't had to determine whether or not a president has been validly elected. And so we'll have to look at what has happened outside of our jurisprudence. So yes, it's going to be a landmark case. And also, when you look at the democratic aspect of it, I think that it will also help in building the democracy of this country in terms of the rule of law being a strong pillar for the development of democracy.
So educate us, what is the basis of this legal challenge? You know, where did it start from? What is the power of the petitioners, as they call them, to go before the court and challenge the election of the president? Why was the president sworn in if in fact his election was being challenged? All of those matters were sort of confusing to some Ghanaian people. The Bar Association did some work in trying to explain, but I would like you to do that if you can. What is the basis of the petition, and why are the things happening the things that are happening in terms of the president and his work, yet his lawyers have to go to court and answer whether he has been validly elected or not, yet the president is doing the work that he's been elected to do?
In terms of our constitutional provisions, once the president is elected, within a month or so of his election, the Electoral Commission, which is a constitutional body mandated to run elections, will then declare who is the winner, and then he's sworn into office. So it follows that whoever has been declared the winner in the meantime will have to take office. So if President Mahama is holding office now, it is because that arrangement is compliant with our legal arrangement in this country. However, the same constitution under which he has been elected also makes provision for the challenge of the validity of his election, and for that matter, the validity of any sitting president's election. So yes, people are wondering why, and probably people are comparing it to what has happened recently in Kenya. It is simply because they have a different arrangement, and that where there is a challenge to the validity of the election of a president, in the case of Kenya, the president is not sworn into office until a determination of the matter. Whereas in Ghana, as soon as the president is declared, soon thereafter, within the period, he has to be put into office. And so yes, until it is otherwise determined, he has a right to occupy that position and therefore to do what is required of him as a president. Probably because the framers of the Constitution, they have realized we don't want to have a hiatus. We don't want to have a space where there is nobody who is ruling this country. Why did we go to court?
No, just before you get to why do you go to court, and I'm asking you this because you are the lawyers for the petitioners. So if you win the case, and President Mahama, when he was president, made me his Minister for Youth and Sports, what happens to me if the court says go and re-elect, or the election of President Mahama was invalid, and go for another election, and President Mahama is a candidate for that election, who becomes president in the meantime? For the ministers that he has appointed, you know, today he sworn in Dr. Kofi Wampa as the governor of the central bank, which is an important function of the president. You know, the monetary aspects of our society and our economy is critical. He has put in place, in accordance with his constitutional responsibility, he's put in place Dr. Wampa. What happens to things like that?
Admittedly, there are no express provisions, either in the Constitution or by statute. But if you consider convention, even the same party handing over to itself, as it were, we have what we call a holding minister. One should expect that if today President Mahama, and hopefully so, should be declared as not being validly elected, he makes way for Nana Akufo, who will, and as we expect, be made president. You will recall also that recently we have in place also arrangements under statute for the interim, the transition period that one president hands over. Although President Mahama may be declared as not validly elected, he will have to hand over in an orderly fashion. Whatever he has done will be deemed to have been lawfully done and will not be questioned. But once he makes way with all his arrangements, including the ministers and other officials that he may have put in place.
If laws have been passed under him, I know the legislature that passes laws, but if he's taking certain decisions, you know, that have an effect on the livelihood of the people, is that what the Constitution means by without prejudice to anything he's done?
Definitely. Where things have been done that are lawful, clearly it is recognized by the law. And the directive principles of state policy say that as far as is possible, a succeeding government must continue what a predecessor government has done. So I expect that on case-by-case basis, whoever takes place, even in circumstances outside of what we are anticipating, I think that the rules will play. And therefore, the incoming president will review the situation and then make a determination in the interest of the people of this country. It is not so to say that he will take a long broom and sweep everything away. That is not my expectation.
So you don't see any legal, constitutional difficulty if your side were to win this case?
I do not, because I expect that the laws will prevail. And thankfully, we have a transitional act in place. I expect that, notwithstanding the circumstances which are novel and unusual, these laws will take place. And it will be as though President Mahama has served his term and is handing over to a new president. So I should not expect any difficulty.
Tell us now why you went to court, just before I take the break, very briefly. We all know that you are in court, but why? And what's the constitutional basis?
Nana Akufo, Dr. Bawumia, Jake Obetsebi Lamptey as petitioners, and first and foremost as citizens of this country, have come to the conclusion that the results that were declared by the Electoral Commission were in fact wrong, and because they are vitiated by a variety of irregularities, statutory violations, malpractices. And these certainly makes the declaration invalid. The Constitution makes provision that should you have any reason to challenge the validity of the election of a president, then of course you could do so by bringing a petition within 3 weeks of the declaration to challenge the validity in the form of a petition, and then thereafter, if there is a need, after the respondents have filed their processes and they ask for what is called further and better particulars. That is to say, if the parties feel that there are matters that are not so clear and they require to have them cleared, then they will make that application. And if the court so finds, will give the opportunity for those papers to be fined. And then when that is closed, 15 days thereafter, then the hearing ought to start. But of course, it didn't happen like that in this case, because there were a lot of intermediary applications that the court had to deal with. And it started with the application of the NDC party, asking the court to join them as interested parties in the matter. John Mahama was the principal respondent, plus the Electoral Commission. John Mahama was sued because the statute says that because he is the person, the validity of whose election is being challenged ought to be made a respondent. So he is a statutory respondent. The Electoral Commission, the statute also says that if there is anything that you have against the Electoral Commission in the way that the election was conducted, then also the Electoral Commission may be made a party. It is in respect of these. And indeed, the complaints in terms of the irregularities, the statutory violations and malpractices that we identified and formed the basis of the petition were largely directed at the Electoral Commission. And therefore, in this wise, Electoral Commission, for us, is the main respondent. But John Mahama has been joined because the law
says he should join so that he didn't join the NDC because he didn't think that it was necessary.
At all, and we still think that the NDC ought not to have been joined.
Even though we now know that the Supreme Court disagrees with you and 6 of the judges thought that yes, the NDC ought to be joined. But there was another matter that confused lay people when in the beginning it was reported that you were worried about the role of one of the judges, actually the president of the court, His Lordship Justice Atuguba, as it turned out to be. How did that matter get resolved? Was it a real matter? Did the media just make a mountain out of a molehill?
To start with, we thought it was a matter of sensitivity. And we also felt that, notwithstanding whatever observation we had made in respect of one of the panelists, and I insist on the expression one of the panelists, because you would observe that throughout the period that the matter was burning, we never disclosed the identity of the person that we took objection to. And for that reason, we requested, and the Electoral Commission, represented by Mr. Kwashi Aiden, as the most senior lawyer in the panel of lawyers, agreed that the nature of the objection that we needed to raise, as we indicated in court, should properly be held in camera. So we went and made our observations.
In camera means behind closed doors?
Behind closed doors, as also permitted by the rules of court. So when the matter went there and the nature of the objection was raised, the court thought that if we so desired and we wanted to press that matter, then it should be brought in a formal application. Upon consideration, contrary to our expectation that the matter could be resolved quickly in chambers, we decided not to pursue the matter because we wanted the matter, that is the main petition, heard expeditiously. So we wrote to the registrar to indicate that we were no longer interested in pursuing that objection and that we were prepared. Unfortunately, when the court resumed, it was indeed the president of the panel that disclosed that we had taken a challenge to one of them. And therefore, this was the direction of the court. The case will be adjourned without a date being fixed. And indeed, that also really informed our decision not to pursue it, because we wanted the matter heard quickly. Fixing a date, adjourning a matter without fixing a date was going to compound the delay. So we allowed it to go, and then we wrote to the registrar to have the matter fixed quickly so we could go into the substantive matter.
But it means you still harbor something against this so-called one of the panelists.
Naturally, the grounds for which we took our objection remain valid, except that in these matters, you weigh your options and then you determine which is the most expeditious, and then you want to maximize your opportunities and minimize the things that will bring a setback. So in balancing the equation, we decided the best option was to go forward. So the objection...
Then came what would have been your next defeat, which is the court's decision to grant the joint application of the NDC. But of course, after that, there was another matter that we will call victorious on your part, which is the refusal by the courts to grant the petition of some 300 people who wanted to actually join the matter. So that's where we are. Were there any other preliminary matters?
Yes, the Electoral Commission brought an application for further and better particulars. They actually wrote, but we, on our part, felt that what they were asking for was more in the nature of evidence. And by the rules, you do not plead evidence. You plead the facts, the underlying facts of your case. And so, although they could get the information if they properly wanted facts, they wrote to us. But we thought that what they were asking for...
But the court has ruled on that matter.
So they had to go to court with a formal application as allowed by the rules. And so the court ordered that mainly some of them, they wanted the particulars of constituencies, their code numbers, the numbers that we refer to in our petition regarding the irregularities, violations, and malpractices. And this we did. And it could be as tall as the stable.
I see.
Yes,
all of that.
Because they were indeed
Listeners tonight, would like to hear from you, if you're able to tell us some examples of some of those violations, irregularities, and malpractice. And I see that throughout this conversation, you've been using the wording of the courts, the violation, malpractice, irregularities. It means perhaps that you are excited about or you are happy about the issues that have been settled. After the break, we'll come and you lead us through the process of settling these issues. The court said the two parties go and settle the issues amongst yourselves. You are unable to do that. Why you are unable to do that, we don't know. But you came back to the court, and by some process, you have to tell us that process if you don't mind. The court has now settled those issues. And then we can receive your emails on goodeveninghana@gmail.com. My guest in the studio is Sophia Akufo, former Attorney General. Gloria Akufo, I should say, is former Deputy Attorney General, former student of a Brigel Secondary School. I found that out when I was having a chat with her earlier. So after the break, we continue with the program. Your emails are very welcome. Welcome back to the show. Thank you very much if you're just joining us. Madam Gloria Akufo is here. She's former Deputy Attorney General. She's also lead counsel for Nana Akufo Addo in the Supreme Court case that I know all people are anxiously waiting for. Thank you very much for staying with us, Madam. So now let's understand the matter about issues that the court settle. What does it mean?
First of all, when the parties have finished filing their pleadings, that is the documents by which they seek to prosecute their respective cases in the matter, it requires that issues arising out of the pleadings be set down for trial. And these would be in the nature of the things that the petitioners are seeking the court to do, as against the things that the other parties are also either asking the court to do or the court not to do. So we took the initiative when pleadings had closed to bring an application to the court. And these are always in the nature of making proposals or suggestions to the court as to what you determine from the issues, from the pleadings as issues. You then also set down proposals for the mode of trial. Now,
the pleadings of your opponent, is it available to you?
Yes.
It's available to you?
Yes.
And yours is available to them?
Yes.
So you're saying that based on that, your side then suggested to the court that based on our pleadings and their pleadings, we think that these are the critical issues that have to be settled.
That is correct.
Okay.
That is what we
Who
did.
asked you to do that? Why did you do that? The court cannot do that by itself?
Ordinarily. And as I say also, the rules that govern these proceedings are new and very restrictive. So as much as possible, the court itself acknowledges that. As far as it's possible, if there is no clear rule regarding a matter, you could fall on other rules that are available within our jurisprudence. So we thought that it being a case for trial, that is, the Supreme Court is sitting as a court of first instance. Therefore, the rules play that after pleadings are closed, there is a need to set down the issues that will guide the determination of the matter. So we took the initiative and filed an application setting out the issue. If you examine our case, we have set out the violations, irregularities, and malpractices in categories. And so our issues were based on whether or not there were statutory violations that we specified, such as the non-signing of the result sheets by the returning officers of the Electoral Commission. So you set it out whether or not in the 2012 elections there were instances of results that were not signed by the returning officers. Then, for example, if you say that there were places where there was no verification of voters before they cast their vote, then you set it out whether or not in the elections there were instances where voters cast their vote without going through verification. So these were the kind of issues that we set down. And of course, you have a general issue and any other or further issues that might arise from the pleadings. And it's not limited to the petitioners, but also to the respondent, such that should you omit, the court itself, being the final decider of what the issue should be, could add them, looking at all the pleadings. But in this wise also, the other parties, the respondents, are also permitted to bring additional or further issues so that together the court could make a determination, which is what happened. Now we go to court, and first of all, the lawyer for the NDC takes an objection that it did not lie with us to take that step, that in any case in the Supreme Court, you talk about a memorandum of issues and not an application for issues. Of course, it was a matter of procedure, not of substance, and the court took the position. And as I put it in Chi, so it looked at the substance of what it had before it, and it agreed that it was proper to look at the issues as set down, and therefore refused the application to have ours struck out, because it was requesting that ours should be struck out and an order be made by the court that memorandum of issues be set down, and that we had taken this initiative without an order of a court, and therefore it ought not to be looked at. But what is interesting is that the other party's lawyers, that is the lawyer for Mr. Mahama and the lawyer for the Electoral Commission, had complied with our process, the step that we have taken, and had filed additional issues. So it was the NDC alone that was. Eventually, when they were thrown out, they said we ought to be given opportunity to file issues. And the court said, well, you've had your take, and therefore you did not. But eventually, at that stage, it took the decision that the lawyers should go together and see if they could agree amongst themselves, given what had been filed, so that issues
Let me just get something clear. So there are 3 sets of lawyers in this matter. That is,
indeed, there are 4.
There are 4. So your group, you are representing Nana Akufo Addo,
and
Dr.
his
Bawumia,
colleagues, yes,
and Jake Obetsebi Lamptey.
That's correct.
All of you are representing the 3 of them.
That's correct.
Then you have another set of lawyers representing the Electoral Commission.
That is correct.
Then you have another set of lawyers representing President Mahama.
That is correct.
And another set representing the NDC.
That is correct.
So lawyers for President Mahama are not the same as the lawyers for the NDC?
Not at all, by the record of the courts.
You have different names really, or you have the same names showing as both lawyers for NDC and lawyers for President Mahama?
No, but you can see a lot of cooperation going on amongst the respondents.
Yeah, of course. That's quite interesting. Okay, so are there not too many lawyers in the matter then?
I wouldn't say so, particularly when you're looking at a case as big as this. And as we have both agreed, you and I, it's a landmark case.
So you have about 30 lawyers in there? Because your side is about 8?
Yes.
And so if 8 times 4, if all
they
the
don't
sides,
have that many, really.
They don't have that many?
No. When it started, we had about 3 on the part of Mr. Mahama. And then we had also another 3 on the part of the NDC. And then the Electoral Commission comes along with another 3.
So your side has the largest number of lawyers?
Yes, because we are petitioners
and
we are big.
So now these issues, you couldn't settle them.
No.
When the court said you should go and settle the issues, in that process, were you still guided by the rules of court? Did you have meetings in the court? Did you have it in somebody's office? How does that work?
The court always has discretion to promote some kind of agreement outside of the formal rules of the court. And if the parties are agreed on an issue, they could bring it to the court, and the court then is guided by the agreement in making its ruling. So in this case, the court said, go look at all that you have put before us and see if you can come out with common grounds of what should be the issues in this matter, as well as the mode of trial. Well, we did not want to appear intransigent, but the posturing of the lawyers for the respondents quite showed inherent even in some of the things that they had. For example, the Electoral Commission on its part had issues raised and was asking that our entire application should be struck out, and that what is contained in their application alone should be set up, not even that of the President Mahama should be considered, that ours should be set, and only what they have should be set up as issues for trial. So you could see right away that it would be difficult to find common grounds.
Where did these meetings occur? If you can't disclose, that's okay.
I could. There's really no problem with that. We deferred to the lead counsel for the Electoral Commission, Mr. Kwasi, and so we suggested for him to fix a venue, and he decided it should be at his residence. So we went there, as did the other lawyers, and that was where our representatives went. Not all 8 of us went. Our representative went, and they met, but there were hardly any grounds of agreement. If anything at all, the one thing that they really agreed on was that they were not opposed to our resorting to PowerPoint presentation, because they said a precedent occurred. And the one that came readily to their mind was the quality grain case, in which Dr. Sipayanki used PowerPoint presentation in giving his evidence as one of the accused persons.
Okay. So these meetings sort of collapsed, for want of a better word, and then a letter was published, signed by Akoto Ampao, informing the registrar of the court that the parties failed to come to an agreement. What happened thereafter?
I think after we had written, the letter requested that the registrar fix a quick date for us to go back, because the effect of the adjournment was that our application and, of course, the proposals by the other parties had been put on hold. They hadn't been dealt with. So when we could not come to an agreement, it meant that the court had to formally deal with our application, which was still pending, which is what took us back to court. And the court then comes out and says that we identify 2 main issues. That is whether or not in the conduct of the election. The court
told you that?
Yes.
And you didn't participate in any process? No. There was no arguments back and forth? So the judges sat and then looked at everything and came out with this sort of conclusion?
It was a very short interaction, because remember, we had lodged these documents with the court for some period before we last went to court. So obviously they had occasion to look at it, especially when our letter had gone earlier on to indicate there was no agreement. They had time to look at the papers that had been filed, and therefore they could, and which they did. So when we went, although they invited us to formally move the application, it wasn't a very lengthy interaction. And clearly, they had already determined what the issues were. So they asked one of the members of the panel to read out. And there were 2 issues that...
So what did they read out? If you know?
Whether or not there were violations commissions.
Omissions?
Commissions.
Commissions?
Commissions, yes. Irregularities and malpractices during the conduct of the 2012 presidential elections.
Violations, commissions, irregularities, and malpractices.
Yes.
Now, when the court comes to look at these matters...
and there was a second.
Sorry, that's a second. Let's
there was a second. The second was that whether or not these violations, commissions, irregularities, and malpractices, if they did occur, affected the outcome of the elections. So these were the two broad issues that the Supreme Court
has... Whether it affected the outcome of the elections.
outcome of the elections.
That is to say, whether it affected who became the winner and who became the loser.
That is it. If the conditionality is that, should you come to the conclusion that these infractions occurred, did they affect the outcome of the elections, such that if they had not happened, the winner would have been different?
The results would have been different.
That is it.
Now, when the court comes to look at these matters, and you are an experienced practitioner at the bar, how will these words be understood? Would it be by the Webster's Dictionary or the Oxford Dictionary, or there are legal implications to the way in which commissions will be understood, violations could be understood? Can my 9-year-old son open the dictionary and look at violations and believe that that is the way in which the court will look at it as well? Or
yes.
Are there other meanings?
Yes, ordinarily, with the exception of commissions, which is interpreted to also include omissions. When you take violations, it means that the breaking off, going contrary to. When you take
going contrary to law,
yes.
convention, practice?
Yes, because we said statutory violations. So we are saying that in some instances in the conduct of the elections, some statutes were broken. And indeed, we meant also the violation of the constitution of the country.
Okay.
And then when you come to malpractices, it means that things that were not permissible to be done in the conduct of the elections, so that they were not just mere statutory. They would come outside of the statutory violations, but conventionally were not permitted in the election. Then irregularities.
Okay,
yes.
Irregularities.
Then irregularities means that things that were done that were not right, they were not regular, outside of practice and convention as far as the conduct of elections are concerned. And then commission, the do's and did not do's that occurred in the election such that it affected the outcome.
So something like when you normally sign, you didn't sign. When
you sign, you should sign, because when you go to the Constitution, it's quite clear on the face of the Constitution.
Okay, the way these things must be done.
That when the polls are closed, the ballots are counted in the presence of agents and also parties if necessary. Thereafter, the returning officer shall, and it is mandatory, in the presence of the candidates or their agents if they are present, shall sign before declaring. So it's quite clear that before you can actually declare and make the results valid, you shall have to sign. So in our view, that is a violation of the Constitution. And if that has happened, then of course, anywhere that such an infraction happened, then the result ought not to have been reckoned.
I have to say that the views expressed by Learned Counsel Gloria Akufo are the views of herself and her legal team. They are not our views. They are not the views of this program or the views of Metro TV. If you have been watching the program, we had hosted Adawudu last Tuesday, who also gave the views of the other side. So we are raising the questions so that we may get answers. I see that the emails are piling up. I'll read them in a minute. But let me just get some clarification on something like malpractices. And you say that perhaps the normal English expression will be applied in a process like that. If two people slap each other at the polling station, is it a malpractice, irregularity? If in the process they cause a derailment of the process because of the queue, and people in the queue take sides one with another of those in the quarrel and in the brawl and things like that happen,
Well, that will be a misconduct that will tend to be disruptive of the election, and once it does not directly affect the results, it will not fall into the category. And that's why we have security men there who will make sure that...
So that's really my question. So all of these things, violations, commissions, irregularities, and malpractices,
So we have instances in our petition, for example...
You're talking about those that actually affect how ballots were counted, how they were recorded, and stuff
such as that. In the results, you will have a special sheet that has been prepared by the Electoral Commission containing information that enables you to provide information on the sheets, such as that how many ballots were issued at the beginning of the poll.
Well, that's already there on the
It is there. It is provided.
It's a column that must be filled.
There are columns that have to be filled.
I see.
And you have where they say the number of ballots cast, the number of registered voters at the polling station, the number of people that cast their votes, the number of valid votes, the number of rejected votes. All these are there. So, for example, when you go to the sheet and you find where it says that you can only vote by the rules, it is law, that you can only vote where you have been successfully verified. And then you find a box that says that so many people voted without verification. There is a problem.
I don't understand that. The same pink sheet says we know that people must be verified by biometric verification, as we were told. But you're saying that a pink sheet had a column to record people who voted without biometric registration?
That is correct. And it states...
So they anticipated that some people will vote without verification?
Implicitly, quite clearly, it meant that provision was made for it. We are being told by the Electoral Commission that these sheets were prepared before the decision was made that where there is no verification, there shall be no vote, and that those boxes ought not to have been filled. I don't want to go into the merits of the case.
We don't want to hear. We are not the court, so we don't want to hear that either. We just want to understand what's going on. So we have now gone past the issues. Let me come to two critical questions. I believe I do have time to do that. I'm being urged to take a second break, but let me look at these two critical questions when we come back. Joy Online has reported you, Madam Gloria Kufu, saying that at the end of the process, you expect the court to deduct some number of votes from President Mahama, but also deduct some number of votes from Nana Akufo Addo. That's amazing. Can you explain that?
Because it's like adding rotten stew to good, fresh stew. Where it is found, for example, that voting took place where there was no verification, and a number is put there.
Of the number of people who voted?
Who voted there. Those have been reckoned. But when you take that, you are not able to tell for whom
they
voted for. And so since you cannot tell, then the entire result at a specific polling station ought not to have been added. And therefore, you will deduct from the total number of votes that have been credited to
each of the candidates.
Each of the candidates, you subtract from them.
Let's do the mathematics to see whether I get you. So you have a polling station, 200 people voted at the polling station, which is the standard. You're saying that it records maybe 75 people voted without biometric registration.
That's correct.
Now that then immediately takes them into the area of violations.
Yes.
Okay, so all the 200 people that voted, what happens? Because the sheet will also record J.D. Mahama would have gotten maybe 75, Nana Akufo Addo maybe something, Pakwesi Ndum something. So what happens to those numbers allotted to the various candidates?
The effect is when you nullify the results, remember that at the end of the polls, the whole country constitutes one constituency. So all these results have been put together to determine who won. If therefore these votes that have been contaminated by the non-verification, then the results of the polling station ought to be taken out.
So and you can only the 75 people who voted without biometric registration?
No.
You are cancelling all the 200? You are cancelling
the total valid votes cast there.
So you are taking 200 from J.D. Mahama?
You are taking whatever was allotted to J.D. Mahama, you allotted whatever was allotted to Nana Akufo Addo.
Oh, the one that was allotted to them?
Yes.
Okay. So if Nana Akufo Addo got 82, you take it out?
You take it out.
Because this is an
from
invalid...
From his total vote declared.
Okay, I see what you mean. So you have done the mathematics?
Very well.
So that's a lot of work, isn't it?
It's worth it.
And in the mathematics, you reckon that about 4 million, is that what
Over
you said?
4 million votes are contaminated and
All
ought to be
across the country
and ought to be nullified in over 11,000 polling stations. And when that is done, you'll realize that Nana Akufo Addo is the winner and John Mahama is the loser.
So those allotted, in those 11,000 places, those allotted to President Mahama, take them out. Those allotted to Nana Akufo Addo, take them out.
Because you will not be able to tell how...
And of course, those allotted to Parkway Sindum goes out as well?
All of them. But since the first two
are the critical
ones, those are the two that we are matching.
And so when you do the mathematics, your client wins the election.
That's correct.
When we come from the break, I'll do the emails. I have quite a few coming in asking me to ask you whether your side is worried by the suit that Justice Pega apparently is complaining about Nana Akufo Addo's qualification as a lawyer, whether you're worried by that. We have been told today that Mr. Frank Davis has entered appearance for your client. And then I'll do the emails after the break. We'll be right back. Thank you very much for your time and welcome back to the program. Because of lack of time, let me go straight and do a follow-up to the last one that you talked about in this mathematical arrangement, the arithmetic of taking out votes from your client and from President Mahama. And you reckon that when that is done, and you expect the Supreme Court to do that. Johnson Asiedu Nketia has been giving some constitutional interpretation. And he says that the Supreme Court will be unable to pronounce a president of Ghana. And so the Supreme Court is not seized with the power to pronounce anybody as president. After the issues have been settled by the court, is your side asking the court to do that? And if you are, don't we know that there's an electoral commissioner that pronounces presidents and the Chief Justice swears them in? The Supreme Court doesn't say who won the election. Yes,
we are asking the Supreme Court to declare that Mr. John Mahama was declared president and that declaration is invalid. Then the next one is that rather it is Nana Akufo Addo who won the elections and must be declared by the court as the winner of the 2012 elections. Emphasis on declare.
Must be declared by the court?
By the court.
Can the court do that?
The court can't do that because the Constitution says where you are dissatisfied with the results of an election and you desire to challenge the validity of an elected president, you could do so. And there is a law which sets out the procedure by which that can be done. Indeed, if you couldn't do so, the Constitution wouldn't say so. And the place to do this are in our courts. Of course, we didn't take cutlasses to fight, and it is because we appreciate, and our clients appreciate, that this is not about Nana Addo, this is not about the NPP, that this is indeed about Ghana. Because elsewhere, where they have not resorted to the court, we all know what has happened. Our own Kenya have learned their lessons. We don't want to go that way, and that is why we have done what. In any case, generally, the courts have got the power to order statutory bodies, such as the EC, if they should find that they are either omitting or are not performing their duties well, to order them to perform their responsibility. It is in the nature of such order that we have brought the action. So it is not as though by bringing this action, the Supreme Court is taking over the statutory or constitutional duty of the Electoral Commission. The Constitution itself says that where you feel it is wrong, bring an action by way of petition to the court, and the court will look at it. And the court can order the Electoral Commission to do what it considers right in the circumstances. I don't know where Mr. Asiedu Nketia learned his law, but this is what I learned in law school.
So you're not, this issue about making the rounds in the media that your side may be looking for another election and all of that is not correct? You're actually hoping that by the time the matter is over, without any further electoral processes, your client be declared the winner of the 2012 election?
We are confident that the court will declare our client the winner simply on the fact that we have solid evidence that the court cannot resist in making such a declaration.
Let's talk also about the request on you to file documents of all the 11,000. You mentioned 11,000. The NDC, well, the lawyers for the NDC and President Mahama say that in your evidence or in some process, you actually alluded to 8,000 instead of the 11,000, which the media has bandied about as the extent of malpractices that you have found in 11,000 polling stations out of the 26,000. Is it 11,000 or is it 8,000?
We maintain it's over 11,000 polling stations.
Oh, it's over.
That we have identified. I don't have the exact figure, but it is over 11,000 polling stations where these various violations, malpractices, and commissions, omissions, and irregularities have occurred. The respondents, particularly the NDC, in court, are saying that they, from what we have brought, see that the problems are only in about 8,000 constituencies, because they are alleging that we are doing double counting, what they call double counting. So it's a matter of arithmetic. When they brought it out, the court took the position that, well, that is what you are saying, but they have brought their case, and they say that it is in respect of over 11,000 polling stations. It's up to them to prove their case. And that is if I take a matter to court and I make my evidence available to court, it is on the basis of that the court makes a pronouncement. It is not true that the court has made a determination that the number of polling stations in controversy is 8,000. That is what the NDC is alleging, but we are maintaining our position that our problems are in respect of over 11,000 polling stations.
There's this other terminology that has arisen as a result of this matter. And last Tuesday, when I spoke to the lawyer for the NDC, it came up as entitled overvoting. What is that? What is overvoting? That when I vote twice or when I vote more than twice?
There are two categories of overvoting. One is where you look at the results and the entries. You would notice that the total number of ballots cast when you open the box is more than the number of registered voters at a particular polling stations. We have discovered...
Total number of ballots cast. That is when you add up what everybody, each candidate got.
Yes, when you add up what is entered. You know, at the end of the poll, there are entries indicating that this is the total number of ballots cast after the votes have been counted, and it's entered on the declaration sheet. When you look at that figure, you realize that on the same sheet, the number of registered voters at the polling station are far less than the purported.
And it's recorded on the same sheet?
It's recorded on the face of the sheet.
But that means the recorder must have seen the sort of contradiction.
Well, clearly, they are telling you what they found. At the beginning of the poll, there are entries that are made, including that of the number. You have the name of the polling station. The code is already there, and you enter the number of ballots issued by the Electoral Commission. You also enter the number of ballots that you have given out to voters. And at the end of the day, you count the polls, and then you enter the number of ballots cast. Then from there, you may also have identified rejected ballots, for example, or spoiled ballots. There are occasions where people go into the box and then they mess up, so they can come back and take. But you reckon all these so that at the end of the day, when you add up, it should tally with the number of ballots issued by the Electoral Commission. But you find instances where the total number of votes cast are in excess of even the number of people who are registered at the polling station. Sometimes also, you find out that when you tally the numbers, the total number of votes cast are more than the number of ballots issued by the Electoral Commission. So you immediately wonder where the extra ballot papers came from. These are the sort of things we talk about when you say there were overvotes.
I see. That's interesting. Did you find instances where people voted twice, 3 times, 4 times?
It's not December. I must emphasize that our evidence is on the declaration sheets. And it is not possible for you to say specifically that there are these variances because people voted twice. It's not possible to tell from the face of it. But you can conclude that something went wrong where the number of, because everybody is entitled to vote one, just one. And even if you are casting another vote because you are holding a proxy, the person must be there. So you are casting for 2. So there cannot be an instance where 2 people, 1 person would have voted more than once. So you cannot say from the face of the document that somebody...
You see, these things happened in 11,000?
Over 11,000 polling stations.
All of these violations of votes in this...
In different combinations.
11,000 polling stations, over 26,000?
Over 11,000. And you find different combinations of the violations, irregularities, and malpractices that people did not sign, or that in a place the sheet is not signed, there are overvotes, and you may even find that code, the peculiar code that a polling station must have. You will find that that code can be found in another polling station, which ought not to be, because these are the security characters that are to guide the polls so that you promote the sanctity of the polls. But there are also instances where the sheets have peculiar, that is the ballots, like a check sheet. You have your check.
Yeah, they are peculiar numbers.
They are peculiar numbers. But you find out that where they enter, because when you make your entries of the ballot issued, you will have the numbers from so to so, as in your checkbook. But you find out that these characters also appear somewhere in another constituency, and you wonder what happened.
That must have been some meticulous work that may have been done. I mean, if you were able to come by all of these, information.
It took a lot of industry.
Okay. We do not agree with her necessarily. We are just listening to her side of the story, just so that we can all understand and follow. Let me see if I can do some emails. I have tons of it. A good show and questions. From Rawlings' time, the NDC has never had less than 4 million and overvotes before till the reign of Kufuor. So logically, why should the NDC get less than 4 million votes in the time of Nana Akufo in the face of population census and all that extra, etc., etc.? Well, that's some analysis, some difficulty in getting some of these emails out. So now, after you do what you have to do and file your affidavit on Sunday and all of that, when do you think that the case will be over? Because Ghanaians are anxiously waiting for the case to be out of the way.
Thankfully, the Supreme Court has ordered that apart from the parties themselves who can testify orally in court, witnesses, whatever number of witnesses you intend to call to testify in support of your respective cases, must be in the form of an affidavit. So you don't have to line up everybody going to court to speak. It, however, said that if you can indicate compelling reasons why some other person who is not a party to the suit must testify orally, the court will consider it and may grant that leave for that person. These arrangements are arrangements that will promote efficacy, and it will also promote expediency, so that we'll take a quicker pace. Now, we indicated in our application for directions that in our estimation, and it is an estimate always, that this should not take more than 2 months, and we believe it should be possible.
More than 2 months from now?
More than 2 months, from the 16th.
Okay. Thank you very much, Madam Gloria Akufo. Thank you
very much.
It's a pleasure talking to you.
It's been good seeing you.
I went to Presec, so if you went to Brig Girls, that's a friendly sort of territory.
We have a very good relationship, and I hope that it's been maintained.
Thank you, viewers, for watching, and I hope you understood, and we will continue to follow the matter and bring you the interviews that we can. But Metro TV will be covering the trial as closely as we can. Good night.